see the module number 3, corporate IR and labor law compliances. So in this module number 3, what are the topics we will be discussing is disciplinary action, termination, misconduct, contract labor, SHWW Act. It means Sexual Harassment of Women Workers Act 2013. Shop and Establishment Act, Factories Act 1948, Building and Other Construction Workers Act 1996, Trade Union Industrial Dispute Act 1947, Minimum Wages Act, Apprenticeship Act 1961, HRcareer. So these are all the topics we will be discussing in the module number 3. Module number 3 is such a big module. So in this module, these are the topics we will be discussing. And at the end of this module, at the end of this module, you will know what are the concept that what are the concept of employee misconduct and the disciplinary actions taken by the organization. What are the various acts that is involved in industries or in the manufacturing sectors. That is, the act means the Indian government. According to Indian government law, what are all the acts that the company has to follow, either the manufacturing sector and also the corporate one. And what is the role played by the trade union and the importance of HR audit. The first topic is disciplinary action, termination, misconduct. What are the disciplinary action? So disciplinary action is a kind of reprimand or corrective measures in response to employee misconduct or misbehavior, violation of rules and regulations of an organization, or poor performance. Based on the severity of the incident, a disciplinary action can take different form. A verbal warning, written warning, evaluation of poor performance, a performance improvement, and a reduction in rank or pay, discharge. So what is the disciplinary action? Disciplinary action means the misbehavior or misconduct. An employee is misbehaving with the other employees, or an employee is misbehaving with the superiors. So that is called as misbehavior. So that is called as discipline. So if the employee misbehaves with the supervisors or with the co-workers, then a disciplinary action will be taken. It is also called as violation of rules and regulations. An employee who is not obeying with the organization rules and regulations, and employees who are giving poor performance, even though training, knowledge, skills, whatever the employee is lagging, so that is given by the superior or by the organization. Even though the enough steps are given by the organization, the employees are not performing well. It means it also a kind of misbehaving of the employee. So basically, the employee who is misbehaving with the other workers and with the superiors, and who is not obeying with the rules and regulations of the organization, who is giving poor performance, even though enough training is given to the employee, even though training and enough skills are provided, enough materials are given to the employees, they are giving poor performance, means that is also considered as a misbehavior of the employee. So these are all the things when employee is doing in an organization, means he is eligible for disciplinary action. The employer or the HR department, they can take disciplinary action for that particular employee or over that particular employee. So what are all the, based on the severity. So if the employee, say for example, an employee is not obeying with the rules and regulations of the organization, means initially a verbal warning will be given. HR will call the employee and a verbal warning will be given to that particular employee, saying that, see, you are not obeying the rules and regulations of the organization. If you continue to do the same, a disciplinary action will be taken against you. So you have to be very careful and you should obey with the rules and regulations. Like that, a verbal warning will be given. Even after giving the verbal warning, the employee is doing the same means a written warning will be given. A written warning saying that a letter will be sent or email will be sent to the employee saying that even though so in so and so date the HR department has given you some warning for not obeying the rules and regulations of the organization, but you are continue to do the same. So we are sorry to inform that we are going to take a disciplinary action against you. Like that, a written warning will be given. So even after getting a written warning, the employee is not obeying the rules and regulations means then disciplinary action will be taken. How the disciplinary action will be taken? Like a reduction in rank. The employee, the HR can suspend the employee. They can give a low payment. Like lower payment means, say for example, if the salary of the employee is 10,000 means they can reduce the salary to 7,000 or 9,000. So they can reduce his salary, or they can go for a suspension, or if there is any clause in the offer letter saying that if the employee is not obeying the rules and regulations of the organization, immediately they can terminate the employee. So like that, if there is any clause in the offer letter, according to that clause, the HR has every right to terminate the employee. So, so that is the disciplinary action. The disciplinary action, once you cannot, once at a time, you cannot take a disciplinary action against an employee. If the HR has found that some employee is not behaving properly in an organization, means at one step, the HR cannot terminate the employee. First, they have to give the verbal warning, then written warning, then only they have to go with the disciplinary action. So this is the procedure for disciplinary action of the employee. Again, evaluation of poor performance. So if the employee is performing low in their work means, so they have to evaluate the performance of the employee. And they have to provide training to the employee, even though if the employee is not working properly, or even though if the employee is giving low performance after providing training to the employee, then they can go with the disciplinary action, saying the reduction in rank or pay or termination. Like that, they can proceed for disciplinary action. The types of behavior qualify for disciplinary action. What are the types of behavior? That is that the HR can or the organization can take a disciplinary action against the employee. Instances that require disciplinary action because of their egregious nature of the misconduct. Violation of rules, violation of the safety rules or safety practice, sexual harassment or assault, especially in workplace, fraud including unauthorized use or misappropriation of fund, theft, discrimination. So these are all the behavior. If the employee done this kind of behavior in an organization, the HR has every right to take disciplinary action against the employee. So first is violation of safety rules and safety practice. Violation of safety rules and safety practice means, say for example, employee is working with the machinery. So if an employee is working with a machinery means they have to wear safety goggles, they have to wear safety gloves, they have to wear safety boots. So if the employee is not wearing this kind of safety gadgets means, then the employee, the HR can warn the employee verbally. If the employee is continue to do the same, then a written warning, or they can discharge or they can terminate the employee, saying that the employee is not following the rules and regulations of the organization. Next is sexual harassment or assault, especially in workplace. If in workplace the employee is doing some harassment of women employees, misbehaves with the women workers of the organization, or the employee unwantedly the employee is teasing the women workers. So these are all considered as a sexual harassment or assault. So if the employee behaves in such a manner, then disciplinary action will be taken. Now, fraud, including unauthorized use and misappropriation of funds. So this will happen in the accounts department. So if the if the employee is involving any fraud, or they are misappropriation, that is the funds are misused, the funds of the organization is misused means, then employer is having every right to take disciplinary action against the employee. Theft means if the employee is involving in theft of any employee's property like machineries, gadgets like laptops. So if the employee involves in any theft, then disciplinary action will be taken. Then is discrimination. Discrimination, if the employee is involved in any discrimination based on caste, creed. So these are all also considered as misbehavior of the employee. Then the employer can take disciplinary action against the employee. Next, employee misconduct on termination. Employee misconduct is an inappropriate behavior or deliberate violation of a written or implied employee policy. Termination of employment refers to end of an employee work with the company due to downsizing, poor performance, and or redundance. The termination process will be included with the approval of HR department conducting an investigation to justify the decision. The employee misconduct. Employee misconduct is inappropriate behavior of the employee, or the employee is deliberately, they're wantedly violating or they're wantedly not obeying the rules and regulations of the organization. So that is called as misconduct. What is termination? Termination means the employer will end the employer will end the employee's work with the organization. So it can be based on anything. If the employee breaches the contract of the organization, if the employee misbehaves with the organization, or if the employee misbehaves with the superior of the organization. So these are all the causes where employer can terminate the employee. Okay, they can put an end to the work of an employee in an organization. If the employee is giving poor performance in their work, then they can terminate the employee. But the termination is a process. So termination, all of a sudden, you cannot terminate the employee. It is a process where you have to, there is a procedure, and that procedure should be followed to terminate the employee. So what is that procedure? That is the disciplinary action. First, you have to give the verbal warning, then written warning, Even after the employee is continue to do the same after getting the written warning, then you can proceed with the termination or any other disciplinary action. And that disciplinary action that involves with the approval of HR department. Without the approval of HR department, no termination will be conducted for an employee. And that HR department, that HR who involves in the termination of the employee, they have to conduct an investigation. So whether the employee is misbehaves with the employee with other employees, or um, what is the charge, what is the charge on the employee, whether they have misbehaved with your employers, sorry, or whether they have whether the particular employee misbehaves with the other employees, whether the particular employee involved in sexual assault, or whether the employee is involved in theft or any misappropriation of funds. So a deep investigation should be done on the HR side. Then only termination or any other disciplinary action will be taken against the employee. How to address and handle employee misconduct. So how you can address and how you can handle the employee misconduct as a HR of the organization. You have to get an efficient, effective disciplinary policy in place. First of all, you have to get a or you have to prepare a effective disciplinary action or effective disciplinary policy for the organization. Without the disciplinary policy, you cannot proceed with the disciplinary action against an employee. So first of all, or initially you have to get a proper and effective disciplinary policy for an organization. Outline a process for reporting employee misconduct. Investigate any and all claims of employee misconduct. Gather information, document everything related to the incident. React swiftly but carefully to workers in misconduct. Communicate the company policy on employee misconduct. So first you have to get the you have to prepare the proper and effective disciplinary policy for the organization. Next, if you have any case of disciplinary, if you have any case of case for disciplinary action, or if you have any case that employee is misbehaving with other employees, means first you need to get the information. You need to get the report from other employee that a particular employee is misbehaving with the other employees. So first you need to get a complaint from the employee. The next step is you have to investigate. You have to, as a HR of the organization, you have to investigate with the other employees of a particular employee who involved in the misbehavior or misconduct. Then you have to get a written information, all the document, what are all the evidence. You have to collect the evidence related to that particular incident. Next, you have to, as a HR of the organization or as a HR of the employees, you have to react in a quick manner. That is, you should not delay the, or you should not slow down the process. Instead of that, you have to quickly react to that incident. Then you have to communicate the disciplinary policy of the organization with the employee who involved in the misbehavior or misconduct. Next, decide on the external communication plan. Decide on the external communication plan means you have to decide whether the particular behavior of the employee is whether the particular case that can be solved within the organization, or you have to depend upon any other external communication, or you have to sort for any police help or lawyer help. You have to decide on that. Considering the external investigation support. So if you have considered any external investigation support means, say for example, you have decided that this particular case cannot be solved within the organization, and you have decided that some external support is needed to solve the case means, for you have to reach that help, and you have to investigate, you have to give all the evidence that you have collected in such particular case. For that particular case, you have to give that evidence to the external committee. Next, review the document with the employment attorney. Next, along with the external support, where you are as a HR of the organization, you have reached some help of external support. So to that external support, you have to review the document. What are all the evidence you have collected? What are all the information you have collected? That information you have to review along with the external committee. Next, train the employees from day one on your misconduct and disciplinary policy. So if you are sorting any help from the external committee, then they will take care of that. So once, say for example, in your organization, an employee is involved in some misbehavior. So if, as a HR of the organization, if you can solve the problem, means you can solve the problem and you can make the employee aware of the disciplinary action, and you can proceed with the procedures of disciplinary action. But if you find that you cannot solve the problem, some external force has to be involved in the case, means you can give, that is, you can approach for the external force. Either you can go to police station or you can go to labor court. So if you proceed with that external committee, or if you are proceeding with that external support, means whatever the evidence or information you have collected, you have to give that information and evidence to that external committee. Then they will take care of it. Okay, so if that external support is calling you for any supportive document or any support, means you have to support that committee. So until then, your work is over. So you need not involved in that case. So once you proceed with the external committee, then they will take care of that. Whatever the judgment, whatever the investigation, they will do. And apart from that, you have to train your employees you have to train your employees on your policies, on the organization disciplinary policies and procedures. So you have to maintain the consistency. Continue to review your employee misconduct policies. Continue to review your employee misconduct policies means every now and then, once in 3 months or once in 6 months, once in 3 months, you have to conduct a meeting. You have to conduct a meeting and you have to make or train your employees on your disciplinary policies.